Excited Utterance, the Evidence and Proof Podcast, Episode 167, Jack Whiteley, the Three-Verdict Problem. Welcome to Excited Utterance. I'm your host, Ed Chang from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Jack Whiteley. Jack is an associate professor of law at the University of Minnesota, where he writes in the areas of evidence, environmental law, and property. Our podcast today features Jack's new article, The Three-Verdict Problem, which was published last year in Legal Theory. In it, Jack discusses the Scottish criminal jury verdict system, which features not only the traditional two verdicts of guilty and non-guilty, but also the somewhat anomalous third verdict of not proven. What does not proven mean? And what's its relationship to guilty and non-guilty? Well, that's a matter of some debate, because Scottish judges are basically not allowed to instruct jurors on its definition. Some famous commentators have floated various ideas, and Jack, linking the problem to modern theories of burdens of proof, has his own. My conversation with Jack looks at the three-verdict problem and what it can teach us about the nature of proof in criminal cases. Jack, delighted to have you on Excited Utterance. Welcome.
Thank you so much for having me. It's an honor to be here.
So, the way that criminal jury trials work in the United States and in most other countries is that you get a verdict of guilty or not guilty. Your paper focuses on a Scottish variant that is quite different. So, maybe you can tell us a little bit about the Scottish system and perhaps why it's different.
Yeah, so as you say, in the United States and in many familiar criminal verdict systems, there are two verdicts, not guilty and guilty. Guilty is a verdict that licenses criminal punishment, and not guilty is a verdict of acquittal, which means that the defendant or the accused cannot be tried again for the same crime. In Scotland, for several hundred years, there has been a third verdict available to juries. So, in addition to guilty and not guilty, there is not proven. And not proven has all of the same legal results as not guilty, in that it's a verdict of acquittal and doesn't permit a retrial. But its precise meaning is something that judges in Scotland are very reluctant to instruct juries on. And so, as a result, in most cases, juries are simply instructed that there are two verdicts of acquittal, not guilty or not proven, and that neither permits a retrial. And the prevailing understanding in the scholarship seems to be that this is basically a historical accident that had to do with 17th century special verdict forms that maybe we can discuss. And then the other interesting aspect of this is that the verdict might be about to be removed. So there's a bill that's currently going through the Scottish Parliament that, my understanding, would turn Scotland into a two-verdict system.
So, say a little bit more about the history. You said that it came out of special verdict forms. How does that lead to the not proven classification?
Yeah, so there's a lot of mystery in this history because it is from the 17th century. But early in the 17th century, there was a system of special verdicts in Scotland that asked juries to affirm whether a set of factual claims was proven or not proven. And then during that century, that system came to an end, and the system turned to one in which there were traditional verdicts of guilty or not guilty, and not proven somehow survived as a third verdict. And it seems like, Scottish jurists, Scottish courts, Scottish lawyers, then the questions for exactly why that happened do not have obvious answers.
Now, given how things operate today, are these not proven verdicts common?
Yes, so my paper is really interested in the deeper theoretical questions rather than the practical implications. And so today, the Scottish juries are evidently told that there are two verdicts of acquittal and that they may choose either one, and that these verdicts are awarded, I think not infrequently, and often I think they are awarded in cases in which the offense is particularly serious. This is something that comes up in a lot of the literature. So, homicide case and other sorts of cases.
The court doesn't give the jurors a whole lot of information about what the distinction is between not proven and not guilty. And this is why, in fact, from a theoretical angle, you're trying to suss out what the differences might be. But you mentioned in the article, primarily in passing, that there are some surveys or that some people have tried to figure out what the popular meaning of not proven is. And I was wondering if you could just say a couple words about that. What do people normally think not proven means when not given any advice from the court or any theoretical structure to think about this?
Yes, so this is an interesting question. And so, as part of the process of the potential criminal justice reforms that might lead to the removal of the verdict, there have been a variety of interesting studies on mock juries to try to figure out how such juries. Much like in the United States, there are pretty strict rules protecting the secrecy of jury deliberations in real trials. But there are mock juries to have them watch an invented trial and then to see how they deliberate on it. I think that insofar as there is conventional wisdom as to the verdict's meaning, I think that it is not proven falls somewhere in between not guilty and guilty as an assessment of the facts of the situation. That seems to be something that commonly comes up in literature. But beyond that, the Scottish Courts of Appeal tend to be reluctant to permit jury instructions that describe it in detail. And so it's actually an interesting question, and I think an empirical one about what juries in practice take it to mean, and one in which there's been a lot of very interesting research. Although that's not the focus of my paper, it's very interesting to read.
Okay, so to think about what not proven means as a theoretical matter, your paper dives into theories of proof, or I should say, theories about the burden of proof. And on this podcast, we've talked about a bunch of these over the years, but let me give you a chance to review them. I think you come up with a really quite reasonable and succinct typology of the different ways that scholars have thought about the burden of proof.
Well, thank you very much. Yes, so this comes from inquiries into, what precisely the beyond a reasonable doubt standard might mean, as well as other potential burdens of proof might mean, like the preponderance of the evidence standard in civil cases. And I want to suggest that there are at least four different ways of understanding it. There may be more, but at least four that I consider in this paper. So one would be the classic traditional way of what does it mean to ask a jury to determine whether something has been proved beyond a reasonable doubt? Well, it means something like a probability assessment. It's asking the jury to assess some probability that in a criminal case that the crime has been committed. So it might be 90%, might be 95%, might be 80%, might be 99%, but some probability that the crime was committed. That's one way of understanding it. Another way I end up arguing for in this paper is based on an epistemological idea called full belief, which is to say something distinct from a probability assessment, but rather to just take something as true. If we were going to translate it into probability, we could only translate it into something like a certainty, even as we know theoretically certainties can be quite rare. Then the third way I consider is the relative plausibility account, which is a variety of different kinds of arguments that go to different things, but I think in some cases at least go to what the legal standard of proof means, including in criminal trials. And then fourth is an argument about probabilistic knowledge, which again has been made by philosophers of knowledge as to a way to understand the meaning of the beyond a reasonable doubt standard. And this is to argue there's a difference between thinking that there is a 95% chance that the defendant committed the crime and knowing there's a 95% chance. And it's that second state of mind that is what the beyond a reasonable doubt standard is asking for.
You use each of these proof theories as a lens for thinking about the three verdict model and thinking about what not proven means. Perhaps you can sort of apply some of these. And in your paper, you have these really helpful diagrams that help map out exactly what's going on. And that's going to be difficult to replicate from an audio perspective. But maybe you can give a short synopsis on how these various theories of proof help us think about the three verdicts.
Yes, so thank you. So I first became interested in this topic when I was a law student and I took evidence and I also took a philosophy of law class. And I became interested in the proof paradoxes in the American context. And then that was the real impetus for this paper, and seeing about how some of these arguments might apply to a system with three verdicts rather than just two. The short answer is it's complicated. But the longer answer would begin with two different arguments that have been made in the 19th century about what precisely the relationship between the not guilty verdict and the not proven verdict is. One is offered by A.V. Dicey and another by William Forsythe, the two 19th century jurists. And they give what really seem to me to be distinct accounts. So Dicey says that when we think about the not guilty verdict in a three verdict system, that the not guilty verdict must mean more than it means in England, and it has to amount to a moral acquittal. The quote is, "It must signify not only that the jury are uncertain whether the prisoner committed the crime, but, what is a very different matter, that they are convinced that the prisoner did not commit the crime." And so Dicey gives us an image that I think is maybe best expressed as if we think about a globe with a north and a south pole. The guilty verdict is at one pole and the not guilty verdict is at the other. And then you have the globe in between, and that's for the not proven verdict. The idea is that not guilty means something different in a three verdict system like Scotland than it would mean in a two verdict system like England. That's Dicey's argument. Forsyth, on the other hand, argued that, in fact, the not guilty verdict should be understood as meaning something similar in both the three verdict system and the two verdict system. And so he says that the not guilty verdict in Scotland implies only that the legal evidence is not sufficient to produce that degree of certainty which would justify or render safe a conviction. And so then this would mean that the not guilty verdict in Forsyth's understanding would encompass a wider range of cases and a wider range of acquittals than in Dicey's estimation it would. And then not proven would be reserved for some smaller category of in-between cases. So that was a 19th century debate. And I think what's interesting about it is that both Forsyth and Dicey agreed on the meaning of a guilty verdict, or at least they didn't discuss it really in this case. But we now know that in the contemporary world, the modern day, there are a lot of very interesting and different takes about the meaning of a guilty verdict, even in simpler two verdict systems.
Yeah, and just to summarize, so Dicey's view is there's a very large middle that is not proven, where you're effectively not certain of either guilt or non-guilt. And Forsyth's view, and you can correct me if I'm wrong, but it seems to me that that is much more where not proven is, well, we kind of think he probably did it, but we're not so sure as to say that that's beyond a reasonable doubt. So there's a kind of taint that is given to the non-proven verdict in Forsyth's opinion.
Yes, that is my interpretation of Forsyth. And that's part of the reason why Forsyth is actually arguing in the 19th century that Scotland should not have the not proven verdict. So yeah, as you describe it, and that gives a reason to why for Forsyth not proven causes issues with the presumption of innocence in criminal trials.
Which account, and here I think the way to describe this is both in terms of theories of burdens of proof and between the Dicey Forsyth debate. Which account do you find most compelling and why?
Right. So there's first of all kind of an interesting threshold question about how to go about answering this question conceptually rather than as a matter of how the verdict tends to operate in practice. So one of the things that I put aside in this paper is pretty much the entire pattern of actual jury verdicts in Scotland over time and how often the verdicts are delivered and so on, because I take it that in the absence of instructions about the meaning of the verdict from courts, it's going to be difficult to gather information conceptually about the verdict's legal meaning from jury verdict patterns, which I think is one reason why this paper ends up being pretty abstract. But I take it that a conceptual understanding of the three different verdicts, a solution to the three verdict problem, would be one in which there seems to be non-arbitrary distinctions between the three verdicts. And so, what do I have in mind when I say arbitrary? Well, something like a percentage threshold seems to me like it might have some arbitrary characteristic. That's to say, if the beyond a reasonable doubt standard requires 95% certainty that the accused committed the crime, then that means 95% certainty means criminal punishment, or at least criminal punishment is licensed, and 94% means acquittal and no retrial. And so when I think in my head of what I mean by arbitrary, that's sort of what I have in mind. And so as a result, this is one of the reasons why I'm drawn to the full belief account of criminal verdicts in two verdict systems, which is to say there's just a certain kind of attitude that people take towards things as taking them as true that is distinct from probability assessments. And we go through our lives both thinking there's going to be a 60% chance it's going to rain this afternoon, and also thinking, say, I look at my watch and it says that it's 11:30 a.m. and I just accept it as true. I take it as true that it's 11:30 and I don't have any probability assessment less than one what that is. And so I suggest that if we adopt that full belief standard as the requirement for the guilty verdict, then we could combine that with A.V. Dicey's account if we're going to try to avoid arbitrariness and say that, well, that means that a not guilty verdict in the three verdict system would ask for the same kind of attitude to the idea that the accused did not commit the crime. So the idea is if I, the juror, believe that the accused committed the crime, then it's a guilty verdict. If I believe that the accused did not commit the crime, it's a not guilty verdict. And if I don't have either of those attitudes, then it's a not proven verdict. Though I emphasize again, this is really just a conceptual account rather than one that's based on any kind of empirics about how the verdict is actually used in Scotland.
It's really interesting. It occurs to me that this is very similar in forensics, where you have the match, no match, and inconclusive, which famously is done in the fingerprinting area, and often gives people who are trying to assess the accuracy of fingerprints heart palpitations, because then the question is, what do you do with the inconclusive, and how do you assess accuracy when there's inconclusive? But it's a very interesting analog, or at least a linkage there. Let me sort of move to some broader implications. Say we adopt your view of this, that Dicey has it right, and it's really a full belief view. Then what is there for the Scottish system to learn from this? And then more broadly, what do other systems like the American one have to learn from this?
Yes. So, as I say in this paper, I'm making conceptual arguments, and I'm not sure that there are any direct conclusions to be drawn for the question in Scotland now about whether the verdict should be retained or not. I say that because it's clear that whether or not there is a conceptually compelling and clear way to understand the three verdicts, courts in Scotland are not instructing juries to that effect. And here is an area where I'm very cognizant of the fact that I'm an American lawyer. I have no training in the Scottish legal system. And so it's not really that I think that there are any real recommendations to be drawn for this real life debate for, whether the verdict should be retained or not. But nonetheless, I think it's still worthwhile for academics, for scholars to return to these 19th century questions and figure out whether there's a way to understand how the verdicts are operating with one another conceptually. And then more broadly, for the question of two verdict systems like the United States, this is where the paper ends, actually. I think, well, all else equal, if the full belief account is a compelling way to understand criminal guilt in Scotland, then that might provide some evidence that it's also a compelling way to understand two verdict systems like England and the United States. If for no other reason, then these are different systems, but in the United States, we inherited the common law of England, and England and Scotland are two distinct legal systems, but for centuries they have had various influences on one another in all kinds of ways. share the same language, share the same sovereign. And so this might help give at least some evidence to the interesting ongoing theoretical conversation within the United States about what the beyond a reasonable doubt standard requires.
Final question for you. Anything next for this project, or if not, other evidence pieces in the works?
Yes, so I'm really interested in returning to some of the questions that were actually my very first paper in the Mississippi Law Journal about trying to understand legal proof in two verdict systems. So I'm interested in going back to that and seeing if there's any further progress to be made, given that there have been a lot of very interesting, both philosophical and arguments from law professors, practitioners about how best to understand legal proof. This is a very early stage project. But then I'm also interested in property and environmental law. There's two other areas, and I'm currently working on a paper on property law and climate change.
Well, Jack, really enjoyed the opportunity to talk about the Scottish three verdict system and how it might help us think about burdens of proof more generally. Great having you on the show.
Well, thank you so much. It's been really great talking with you.
Despite what appears to be accidental origins, the Scottish three verdict system is actually quite instructive and generative. Sometimes I think that evidence is one of those areas where comparative work is especially useful because there are certain shared goals. Here, the shared goal being getting at the truth, or at least assertions of the truth. So, the three verdict system asks a rather fundamental question about criminal trials. Is the goal of a criminal trial simply to resolve disputes? In other words, to determine if the accused is guilty? If so, then the two verdict system that we have works perfectly fine. Either the prosecution meets its high burden of proof, the beyond a reasonable doubt standard, or it doesn't. But if we're looking for something else in our criminal trials, such as a truthful assertion of fact, then perhaps the three verdict system is an option that we should consider. The three verdict system allows a jury to say not only guilty or not guilty, but also, in effect, we don't know. Not guilty under a three verdict system is truly saying not guilty, meaning innocent. We don't know, and other kinds of failures of proof are stated explicitly as not proven. These more nuanced assertions about facts, though, come with both costs and benefits. The benefit, I think, is that victims who are unable to obtain a guilty verdict may feel more heard and vindicated. But of course, these benefits come at the cost of defendants, because a defendant who is found not proven still lives potentially under a taint, which is along the lines of William Forsythe's theory of the not proven verdict. The final thought I had goes back to forensic determinations, which I mentioned in my conversation with Jack. Forensic examiners, such as fingerprinting experts, have long had this third option. They can decide match or include, exclude, or inconclusive. And this inconclusive category creates all kinds of difficulties when statisticians are trying to assess what the error rate is of a forensic technique. How do you really determine error rate when an examiner or any kind of diagnostic tool can basically punt and say it doesn't know or he or she doesn't know? So, inconclusives and not provens are not without their perils. But in some ways, I think they are refreshingly honest. Sometimes evidence is not particularly clear. And in those cases, don't we want decision makers to say precisely that the evidence isn't clear rather than forcing themselves into an on-off determination, which could be misleading or lead to other undesirable effects? In any event, my thanks to Jack for raising this interesting Scottish wrinkle to criminal verdicts and using it as a device to explore the burden of proof, both in Scotland and more generally in the rest of the world. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anirudh Morella. Additional production assistance is provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Cheng, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.